Ciao a tutti. This is Prof Jo at Prof Jo Explains. The jury trial of Kouri Richins went 3 weeks, maybe a little more. The jury took fewer than 3 hours, and they also ate dinner over that time. So what made the state case so strong? What might the defense have done differently? And what was the jury doing? And I'm really pleased that we have as a guest today Eric Faddis, who's got many years trial experience. He's been an assistant DA. He's now in private practice in his firm, the offices of Eric Faddis. You've seen him, I know you've seen him on other YouTube programs, including Core TV and Nancy Grace. He is an expert in talking about trial strategy, jury behavior and psychology, criminal law and procedure in general. And so I'm just going to bring him right on. You don't need to have me introduce him. You can hear him in person. Hi, Eric. Such a pleasure to have you here.
Yeah, no, stoked to be here. Thanks for this, fascinating case that just went down. Happy to be here.
Yeah. Okay. Well, let's start with, let me ask you a question. Would you have gone for the death penalty in this case?
Personally, as a former prosecutor, I would not have. I think the death penalty is kind of dying as a potential sentence option. Now, depends on what state you're in, depends on sort of the composition of the county and the jurors. But, we've seen cases like the Aurora Theater shooting in Colorado, where I practice, where the defendant killed more than 10 people. They sought the death penalty. The jury said no go. And so in this instance, I think it's, there are less deaths. It is arguably less egregious, although that's debatable. But I don't think the death penalty would have been the right way to go on this.
Okay. Let's start with the end of it, the closing arguments. What did you think of the prosecutor's closing and the rebuttal closing?
Pretty solid in my opinion. I think when you're doing closing arguments, you really have to connect the dots. You've got to bring everything together, because you've got these jurors, they're not professionals, they're just lay people, and they're given, a smorgasbord of evidence throughout over the course of weeks and weeks. So what is the impact of that evidence? What does it mean? Why does it prove that a person is guilty? I thought the prosecutors did a reasonably good job of bringing all that together, connecting those dots for the jury, and based on the outcome, sounds like those dots connect.
Yeah. And the fact that he used so many demonstratives, interweave the videos, the recordings, I assume you thought that was an effective way to do it?
Oh, totally, Joe. I mean, it's not like 1907 anymore, where you just get up and stand and talk at a jury for hours or something. I think attention spans are different. I think we're so used to receiving multiple stimuli from all different areas, social media, digital, electronic, person to person. And so to have that variability in your closing, to be able to cite to and show different types of media that really sort of tell this story in a fluid way, so long as you could do it and not get tripped up. I think that's super effective, and it's consistent with how these folks are used to receiving information in their daily lives in our modern era.
Yeah, I agree with you. What about his method of presentation? I liked it, but I'm from an area of the country where touchy-feely and warm and cozy, it's not something maybe we see all the time. But what do you think do you think he had a good rapport with the jury? From which, I know you couldn't see the jury, but what's your impression of how the jury saw him and how he interacted with the jury?
Sure. So, Joe, you touch on an important point, because the attorneys have to develop that rapport with the jury. You have to try to get the jury to trust you, and that's not easy. You have to develop that credibility over the course of the trial. And then on top of that, you got to be true to yourself. If you're up there as an imposter, you got a mask on, you're trying to act or sound like somebody else, the jury is likely to see through that. And my impression was that the prosecutor, was able able to sort of put it in their own style, in their own tone. And even though that might not be the preferred tone or style for every single person on the jury, my impression is that they all realize, hey, this is who this prosecutor is, and they're not pulling any punches or hiding things from me. And I think juries appreciate that and can sense that.
Okay. I got another question about him. He did that list of, the closings are not evidence and the openings are not evidence. And let me show you some things. And then he went through a list of about 8 or 9 things that the defense said the evidence would show or prove. And with each one of them, he said there was no evidence. And with 2, I think he said not only was there no evidence, but there was contra evidence. I had not seen a prosecutor do that before. I will tell you, I liked it a lot, but let me hear your reaction to it first.
Oh yeah, that's it goes back to that piece of building credibility throughout the trial, and that's on both sides. Look, if you get up there, Joe, and you're making promises to this jury in opening statement, hey, I'm going to show you X, Y, and Z, and then you don't deliver on those promises, the other side can comment on that, and they can show, hey, they made these promises to you, they didn't deliver, and it sort of casts doubt on the entire credibility of that side, the entire side. So I think it makes sense to point out those promises that were not delivered upon, and just show like, hey, what they told you from the beginning isn't what you saw. Don't believe what they're saying.
I agree with you completely. What I was going to say as a caveat to it is in the Brian Walsh trial, not only did the defense promise that he was going to testify, but the defense also referred to things that the evidence was going to demonstrate that would have come in through Brian Walsh and then didn't come in. And they had quite a long discussion about what the prosecutor would be able to say about it. And the judge talked about giving a very, very soft instruction, different from what happened in Utah. I mean, the defense never objected to it, and it was pretty clear that the judge there would have said this is perfectly appropriate. It doesn't reflect on the defense, has no obligation to put on a case. So that's what struck me, that he was allowed to do as much as he was doing. And is Colorado aligned with Utah in terms of what the prosecutor is able to say? Can you do what he did?
If I was defense counsel, I certainly would have objected, because the legal point you're touching on, Joe, is this idea of burden shifting. So under the Constitution, the defense has no burden to put on a case, to present evidence. They could sit there and play solitaire the whole time, theoretically, and not run afoul of those rules. When the prosecutor starts saying, hey, defense didn't do this and they didn't do that, there's an argument that the prosecutor is shifting the burden to defense by conveying to the jury, hey, the defense should have put on this evidence, and the defense should have objected, saying, whoa, we don't have a burden to present evidence, to deliver on any kind of representation. That's not the structure of our criminal justice system. But I think defense missed an opportunity there.
Okay, so it is a little risky then, however effective it was to do it. Yeah. And they didn't object. So as an appealable issue, they'll have a problem. They'd have to show more than just, there was an error there. They're going to have to hit a higher burden. So
that's right. As defense counsel, sometimes you don't want to be annoying, but with your objections, but you have to object to preserve these issues for appeal. And if you fail to object, your client might be SOL when it gets to the appellate stage, even if it was an error on behalf of the other side. So I am not shy about those objections when I'm on the defense side, and I think there certainly could have been more to preserve more issues for what will surely be an appeal coming up.
Although the judge did shut her down the first time she tried to object to something. He was pretty emphatic and pretty clear, and didn't even let her get the entire objection out before he told her to sit down. So, okay. Well, we're talking about the defense. What did you think about the defense's closing?
You've got to play the hand you're dealt, and you've got to play it as well as you can. My apprehension was that, defense did a reasonably proficient job with what they had. But there was just so much here when you look at the totality of it, Joe. You got the internet searches, you've got the housekeeper from whom Kouri allegedly requested these drugs, you've got these insurance documents that she allegedly forged. That's a lot to overcome on the defense side, and ultimately that they came up short.
Well, let's move into the defense. Should they have put on a defense, do you think? I mean, I know it's hard because they're closer to the evidence and they're making an assessment that to some extent we're doing blind. We can see what we can see, but we don't know what else they had and what some of the worries they would have had with regard to cross. But do you think they should have put on a defense?
I think there were a number of measures that they could have taken in a defense case that they didn't, and that could have helped them. Throughout the trial, the prosecution, I think, was kind of successful in sort of assassinating Kouri Richins' character. And that's not usually, by the book permissible, but those things happen at trial. And they sort of casted her as someone who's deceptive, who is manipulative, those kind of things. I think defense could have put on some character witnesses to show her character for honesty. Certainly she's been honest with other people in her life about things that matter. They could have called those folks as witnesses to sort of neutralize that character assassination, and they did not do that.
Do you think there were witnesses out there that could have testified that she'd been on? I mean, I'm just telling you from what I could see, independent of family members who would have had their own issues.
That's the crux. Oh, of course, that's the crux of it, Joe, is that, you can theorize as a defense attorney about, hey, this is what I'd love the case to look like on the defense side. These are the types of witnesses who would help, but you've got to identify those witnesses. You've got to make sure those people exist, that there are events in Kouri's life where she has been honest and has not been manipulative. And sometimes you can't find those folks. And if you can't find those folks, you can't put on such a case. And so perhaps that was the reason why defense was so limited on that side of things.
Let's talk about that. What was your impression of her from the evidence before trial, from the evidence at trial, from her at counsel table, all of it?
A few things. I think in terms of her actions, I think nearly any reasonable person is going to look at that and be like, this lady has terrible judgment. Like, she is just making crazy calls here and there. She is, I think she came off with respect to those actions as a bit erratic and also detached. And that detachment, I think, followed her into the courtroom. I think at times she appeared kind of aloof, sort of just like detached from reality. One example is sending this letter to her mom that looks a lot like witness tampering. And every inmate is told, hey, all of your correspondences are going to be searched. They're going to be looked at. And so I think in order for someone to send that, they kind of have to be detached from reality, detached from real life consequences. And I'm wondering if that sort of showed through in her demeanor and her expressions. And I'm wondering if the jury picked up on it.
Uh-huh. Yeah. Well, she certainly made faces. I didn't notice because I'm not all that visual when things are, I'm listening, but there were people in the chat that kept reporting as we watched the trial, that she was making faces that are, her eyes would look to the ceiling at times. So my own impression was she would have made a terrible witness without regard to the cross and the evidence that they could have used against her. And it's not by how she was sitting and what she looked like. It was the person that came through, as you mentioned, with the walk the dog letter, in all the things that she did, that I just thought, she wouldn't have, let me put it mildly, she wouldn't have helped her defense at all.
Yeah, I would have been, as her attorney, kind of shaking in my boots if she was insisting on testifying. I think not only the substantive issues you brought up are problematic, but her demeanor and the way that she would be received is so important. And I think that there was a real risk along those lines if she would have testified.
Yeah. So you mentioned the walk the dog letter. Did you think that was oh, look at that in Italian. Wow. Thank you, Elena Bonilla Bad. Appreciate it. Did you think that was the strongest piece of evidence that the prosecutor had against her?
Not the strongest, but I think that it's in line with the prosecutor's theme, right? The part of their theme is that she is sort of manipulative. She's trying to sort of be the puppet master behind the scenes with these insurance policies, with which she's been convicted of, which is bringing about her husband's death, purportedly for her own good. And this letter was just sort of part and parcel of those themes, and so I think the jury saw it as just corroborating evidence of what the prosecution has been saying all along, that she is going to try to manipulate her way out of this, and the prosecutor saying, "Hey, jury, don't let her do that."
Yeah. Did you think there was a piece of evidence that was, the strongest, or do you think it was really all of it combined? And there's part of the walk the dog letter there.
You always look at the totality, of course, but to me, what stood out was the interactions with the housekeeper and the drug dealer. Now, granted, those folks had some credibility issues, and those were brought up in trial. But I think the jury's looking at this like, hey, do you think this housekeeper is just completely making up that Kouri Richins was asking for like the Michael Jackson drug or whatever it was, and that there was this entire ruse that's been completely fabricated involving this chain of drug dealing that ultimately provided the substance to Kouri that she used to poison her husband? I think the jury is like, hey, this housekeeper is not just making this up out of thin air. These interactions took place, and even if the specific contents of those interactions are challenged, I think the jury got the gist that hey, this lady's asking for drugs, and now her husband's dead in a way that is consistent with those requests. That's a big problem.
I assume you think that the defense is try to say he obtained the drugs and he obtained them in Mexico, and law enforcement didn't follow the chain, and if they had, they would have discovered that was just a bridge too far for the jury.
What precisely was the defense? I think that the fact that we're even talking about that is a tremendous problem, because although the defense legalistically has no burden, the jury wants to hear, is there a plausible alternative explanation for what happened? And if so, what's the evidence supporting this plausible alternative explanation? My apprehension was defense couldn't even really articulate exactly what they thought happened, let alone provide substantiating evidence of those things. And I think that was a real hangup for this jury.
Yeah. Do you think they should have gone, they tried to show it. Do you think they should have gone after Cody Wright, the friend, who I thought was really credible because he turned his friend in, and his friend who wanted to go hunting lost his license for several years, for what Eric might have ingested as a teenager in high school?
In my view, I mean, they got to do whatever they can do, and maybe that was all they had to support their theory. But what somebody's doing in high school, that was years and years ago. I may have made some bad decisions in high school, but that doesn't necessarily apply to 2026. And I'm wondering if they would have presented that evidence, how the jury would have seen that. Would they have said, gosh, you want to talk about a reach? This is clearly a reach here. And when you're reaching in front of a jury, they can sense it, just as when you're reaching in front of normal people you're talking to. And so I'm not sure how much dividends that would have paid for them to bring that up.
Yeah. What about, they made some level of point, and she referred to it in closing also, that Kouri really was not in financial distress. What
they're trying to do from the defense perspective is sort of undermine this alleged motive that Kouri's, financial situation was in shambles. She became desperate. She resorted to extreme measures. They're trying to say, hey, well, wait a sec. Things weren't that bad. And I think that is the right path to take. There are other options Kouri could have considered, like bankruptcy or, all sorts of stuff. And so I think it made sense to try to undermine that motive. I think they could have done it a little more effectively, but didn't.
Well, that brings us back to whether they should have put on a defense. Could they, do you think, have brought on their own forensics accountant to say, maybe, yeah, she had all this, all this debt, but the reason why it looks like she's in such financial distress is because she was arrested and never had the chance to sell the properties, or, it's the, you do as little as possible to get them saleable, and then you try to sell for a big sale.
I hear you, Joe. I think, the prosecutor had that forensic accountant who really kind of showed the financial situation that they claimed Kouri Richins was in. And as defense, your response can't just be, nuh-uh. Like it can't just be like, oh, no. You have to like put on your own substantive evidence to rebut that. And so surely they could have hired a forensic accountant. Now, that cost a ton of money, and the prosecutors paid theirs a ton of money.
They did, you're right.
But and so financial resources can come into play, but you've got to mount your defense as best you can, and that would have been a critical element to undermine this motive even more effectively.
So let's play. We don't know what the lawyers were up to, but let's assume they had to know what you just said. So, and they were appointed by the state so that they would have had the opportunity to apply for money to get an forensics accountant to counter what the state's position was, and they either didn't do it or I don't know. Let's say they didn't do it. Would that suggest to you that they couldn't find somebody who was going to come up with a favorable assessment of the financials?
So what I'm wondering, when you have a state-appointed defense, they have resources. They're not the same as law enforcement resources, but there's resources there, especially for a first-degree murder case. And they could have enlisted, or at least explored, the option of having such a forensic accountant. What I'm wondering, Joe, is kind of like you alluded to. Did they consult with some? Did they talk with some? And these folks were like, sorry, bro, like this, I would agree with the other forensic accountant. And then therefore you, of course, don't call that person at trial. So maybe they did make such efforts and just kind of came up short in terms of finding somebody who would agree with their side. That happens.
Yeah, which is, from the viewpoint of a defense lawyer, something with regard to kind of the criticism they get afterwards. Why didn't you put on a defense? I mean, that's the sort of thing that they may have investigated and decided that it wouldn't help. And you can speak to this when you're a defense lawyer and you've made those sorts of decisions based on what you know, and then people criticize it. You could have done this and you couldn't have done that. That can't be the happiest place to be for the defense lawyer.
Oh yeah, especially compound that with just having a murder trial loss. No, that's a bummer. These people are hurt right now. Yeah, it's easy to kind of, for me to like Monday morning quarterback and say, oh gosh, y'all could have done some different stuff. But I think especially in a case of this magnitude, the jury's looking for something from the other side. Look, we spent, 2+ weeks hearing from the prosecution. Okay, well, what do y'all got? And if the response is the defense rests, well, that's not a very satisfying response to that jury.
No, but the only thing you could say is if your response is we're going to put people on that makes it worse, that's not a very satisfying place for the defendant to be.
Oh, of course, yeah. It's not a comfortable position to be in, but even in cases like in the case that I've had where I'm worried about putting on a protracted defense in some fashion, I'll still usually call 1 to 3 witnesses, even if it's somewhat minor, that take jabs, that identify weaknesses, that poke holes in the other side, just to just to create the impression, if for no other reason, that, hey, there are 2 sides to this, and we've shown you the defense side through cross-examination. Now we're going to show it to you in our case in chief. It might be limited, and then you're going to get to decide. But without those measures being taken, I think some jurors look at that kind of with a side eye, like, y'all don't have anything to say?
What did you think of her closing?
Tough case for defense to be on. You got to work with what you have. I think she did a reasonably good job at trying to neutralize some of the financial pieces of this. And in fact, they did some good job pretrial, getting some of those financial counts severed, which is good.
Both of them. Yeah.
But you got to work with what you have, and things were just pretty overwhelming in terms of the prosecution's evidence. It's hard to kind of punch up from that and change the game entirely with just closing argument.
Do you think she should have done more with it's the state's burden, we don't need to do anything, and emphasized or weaved in when she talked about the holes, what she said were the holes in the state's case, weaved it into a better theme of, and it's their job to prove. I mean, she did start out with, proof beyond a reasonable doubt is a constitutional protection, but weave that in better to say to the jury, to try to neutralize the fact that they didn't put on a defense.
You have to. You absolutely have to in closing argument. You got to emphasize it. You got to convey this in a clear way, because normal people, when there's some kind of disagreement, usually want to hear from both sides, and you got to convey to them, hey, this is a different ball game. This is the Constitution governs here. And what the Constitution says is that all of the evidence in this case, the only state side that has a burden is that side. And we don't have to put on any case. And you can kind of explain how defense might be limited. They didn't have dozens and dozens of investigators on their side to be looking into this matter, whereas the government does. That's why the burden's on their side. And so, they haven't met that burden. And then you go into those holes, then you go into those weaknesses. But you need that sort of precept to register with that jury that, hey, the defense really doesn't have to put on a case here. The only burden's on the prosecution. And here's why they haven't met it.
Yeah. Now, she did do that. Did you think she did it as well as she could have, or hit it as hard as she could have?
I think you can't emphasize that strongly enough in a case like this, especially, Joe, where you're not putting on any defense. That's sort of the answer to the question of, God, why didn't defense put on some witnesses or some evidence? And the answer is, well, we did that through cross-examination. That's how this thing is structured. And then the reason we didn't do anything else is because the Constitution, you all agree with the Constitution, right? That's you can understand how someone in Ms. Richins' position might be at a disadvantage. You can understand the reason why we have this one-sided burden principle. And I think you can't emphasize it strongly enough. She could have done it more strongly, I think.
Okay. There's a question in the chat. Let me take this for you. What ethics, what morals would a defense team even have if they knew it's a guilty case? I know you hear this all the time, so.
Oh, yes. Very fair question. So the way that I look at it is, I have these clients, but really my number one client in criminal defense is the Constitution. And what that says basically is that we have to subject the prosecution's accusations to scrutiny. And that's true regardless of whether the client's factually guilty or not. Because if we start just making these selective determinations of in this case, the client seems pretty guilty, so we're just going to accept what the government's telling us in terms of an accusation and roll over. Well, interests become involved with that. Sometimes it becomes political. Sometimes it's a product of the social times, and folks get railroaded, and people are wrongly convicted all the time. And so if we do not subject every single case to that constitutional scrutiny, we risk what is maybe the worst outcome in a government that I can think of, which is a person being put in a box for something they didn't do. And so that's why we need that vigorous check on the government in every single case, including this one, including cases where people believe the individual is factually guilty.
There you go. There's another question in the chat that didn't come up here about whether you think, had she not written or said or done anything post the killing, whether this would have been a much harder case for the prosecution. And let me pull up, Amber, if you can, some of the messages that she was sending with regard to, can you change what the death certificate says, that whole list? We don't have all of them, but we've got some of them. Do we have that or no? I can't remember. Maybe we don't. And if not, okay. That's the question I just did. Let me read some of them. The one that I loved was she was checking into luxury prisons for the rich in America, which I thought was kind of a neat concept. But she had things like, how long does life insurance companies take to pay? Can the manner of death be changed on a death certificate? Is circumstances unknown an accident? If someone is poisoned, what goes down on the death certificate? She had another one that said, can you remotely erase text from a phone? And that was after the police had acquired or seized her second phone. So those are some of the things I think that question anticipates, plus the walk the dog letter, plus all the lies about what she was doing compared to what the video showed she was doing the night of the death and at other points. So if all of that was erased, would she have been acquitted?
Honestly, I think there's a reasonable likelihood of a different outcome if she didn't dig her own grave. Pardon my pun, but she engaged in so much. You look at the bases of the evidence against her. A lot of it comes from her. She's the one who's doing. You're giving the prosecution a gift. You're engaging in this ungodly suspicious activity after your husband just died. If she would have just said, hey, I don't know what happened to my husband, sorry, and I'm really upset about it, and left it there, this would have been a much tougher case for the prosecution to prove. But instead, all of these text or internet searches and the lots of dog letter just reek of guilt. And when someone sees that in addition to the evidence the prosecution had, they start to put it together. They say, hey, this is beyond a reasonable doubt. And now look where she is.
So she helped her own case. I thought the same thing. You watched the Adelson trials, I'm sure. I thought the same thing in Donna's trial. The strongest evidence against Donna was evidence that Donna produced. How often do you see when you're a prosecutor now as a defense lawyer, how often do you see defendants who really help the state make the case by engaging in this sort of conduct?
I would say in some form or fashion, Joe, the majority of the time. I'm telling you that's one reason as a defense counsel, my job is to protect the legal interests of my client. And it's in their best legal interests to shut the heck up and to not be providing statements, to not be, Googling things about death on their phones and stuff like that. Because that, especially in our modern era where pretty much every defendant's cell phone is downloaded in a murder case, that can provide just a trove of evidence for the prosecution and can get them over that hump if they have other evidence which might be more problematic to them. So that happens all the time, and it's going to keep happening. They don't listen to me, so.
That's how my students always were. So let's talk about the jury a little. One of the jurors, I think it was the juror foreman, did an interview this morning, I believe, with ABC. It was an exclusive. And among the things she said was that jurors were struck that, and I'm paraphrasing now, that Kouri at the counsel table didn't seem to have any affect. She also said when they got into the jury that they all started out hoping that they would find her not guilty. That's where they all were, and they just couldn't find anything that pointed anywhere to guilt. She said they got to their conclusions different ways. And what they started out was they went around the room and everyone talked. And she also said, a couple of other things. They felt really bad that their verdict would mean those 3 kids were now without both parents. And finally, I'll give you all of what I jotted down from what she said. that they, and this again is a paraphrase, that when the evidence came out that she hadn't written the book, that it was a ghostwriter, after they had seen, the clip, when she talked about writing it with the kids a year after the death, that they were all just, let me say, flabbergasted. So those were some of the clips. They were out fewer than 3 hours. Do you think in the fewer than 3 hours, they really were able to substantively deliberate on the 5 counts?
I'd have some reservations about saying yes. I mean, look, they were presented with evidence over the course of multiple weeks, sometimes difficult evidence, forensic accounting, that stuff is hard to sift through. There was just so much to evaluate, and I've had DUI cases that deliberate for longer than that. And so if I was Kouri Richins' defense counsel, I'd have some concerns about what went on during those deliberations. In fact, I would try to interview each and every juror afterwards to verify or not verify that they diligently reviewed everything, because 3 hours, and I think you said, Joe, earlier that they also had food during that time. So, if they're eating a meal, sometimes you're not actively deliberating. 3 hours is shockingly short for a deliberation in this case, but there was substantial evidence. So,
yeah. So, what do you think that the clearly from this juror's perspective, the evidence that Kouri had hired a ghostwriter on that book hit with some impact, but do you think that it affected the decision to find her guilty on the 5 counts?
I think, rightly or wrongly, it did. And what I mean is that, the jurors have to consider substantive evidence of, did she have the intent to kill this person? Did she do it after deliberation? Was she the one who caused the death? And the fact that she had a ghostwriter write some book, that's not directly relevant to those pieces. But jurors are human beings. And I think anyone's going to look at that and say, how detached is this person after the death of her husband? She's going on this, ostensible crusade of, oh gosh, this is how you can comfort families when their partner dies, and lo and behold, that's not even her words. That's not even coming from her necessarily. And so I think the jury looked at that and said, what a phony, what a manipulator. And then you look at how she is on the body cam, you look at her 911 call, those things, and you're like, this person is so detached that could they be capable of going to such extreme measures as to poison their husband? Kind of seems like she can.
Mm-hmm. The 911 call, I think, is interesting. How did that 911 call impress? I don't mean impress in the sense favorably, but just have an impression, make an impression on you.
Oh gosh, when these things happen, even though the defense has no burden, the jury is looking at, what would an innocent person do if they didn't do this? How would they act? How would they be emoting? What would their expressions be like? What would their demeanor be like? Would they be acting with urgency? Those kinds of things. And I think the 911 call left a lot of questions in those regards, because I think people looked at that and they're like, gosh, if my husband died and I had nothing to do with it, I might present differently. I might handle that differently. And I think the fact that she didn't just was consistent with the prosecution's theory that hey, she did this, and she's kind of a detached, erratic, poor judgment person, and that's how you'd expect a detached, erratic, poor judgment person to make a 911 call if they had killed their husband.
Mm-hmm. Did you think the 6-minute clock was effective when the 911 call was run?
Remind me again. I'm sorry. The 6-minute clock.
He had a clock running from the time the dispatcher first told Kouri, you got to do CPR, until the time she said she was doing CPR, and it ran for the 6 minutes.
Right. That sort of goes along with what I was saying. Like, my gosh, if somebody's partner was lifeless and not breathing, and the 911 person is saying, hey, you got to do CPR, meaning you got to try to save this person's life right now. You don't kind of like dilly-dally and hang out for 6 minutes. I would put the phone on speaker. I'd be immediately on that individual's body trying to invoke life back into them. And that just wasn't the impression at all that Kouri gave during that call. And I think a lot of people raise some eyebrows because they're like, why would you not try to save the life in an urgent fashion of your partner unless you wanted them to die?
Yeah. I thought the clock was really an inspired idea to underscore.
Smart,
Yeah, it was really, I thought it was inspired. He didn't make a point, and would you have had, if you were the prosecutor, would you have? He didn't make a point that if you're doing CPR, it's very tiring. And anybody who's ever done it knows that you start being out of breath. You have to have people shift in and out because you just can't keep doing it. And I don't recall that even came out. I don't know that he even asked the ME about CPR. Would you have made more of a point with that?
Well, gosh, I mean, if I'm defense,
Not
you need
defense,
to
prosecutor now.
Okay, gotcha. You know, I think they played it reasonably well. I think that in every case, there are these factual circumstances, and you got to decide where you're going to go into the weeds. You got to decide what nuances you're going to explore and convey to this jury, and whether that's going to be compelling. I think the prosecution kind of figured, hey, we've got an arsenal here of evidence, and sort of perhaps rested upon those laurels. And in this instance, it was still enough.
Yeah. So we talked a little about whether there was something that was piece of evidence that was really strong. What about the witnesses? Did you think that, I mean, it's tied into how important their testimony was, obviously, but were there witnesses that struck you as particularly effective on the stand for the prosecution? Obviously, for the prosecution, there were no defense witnesses.
Sure. I think the forensic accountant was pretty darn sharp. And I think the prosecution had some challenges in terms of witnesses. They had some folks who had some credibility issues, who had some stuff in their past, who may have been offered immunity, which can affect what a person's going to say on that stand. And I thought that they managed it reasonably well, considering those potential issues. Thought the accountant was stellar. Thought most of the law enforcement witnesses were pretty spot on. So it seemed like overall a pretty polished presentation to me.
What about the, often defense points to the inadequacy of the law enforcement investigation. What was your impression? Was it adequate? Was it run of the mill? Did they do a great job?
Yeah, I would say I'd land somewhere right around adequate. I think that they did the job they had to do. I think they were reasonably proficient. In every case, there are going to be investigative issues. There are going to be problems. Here they were able to really convey their case in a fashion that the jury could place faith in that investigation. They heard from these witnesses. They were able to say, hey, look, despite potential shortcomings, despite what's coming up on cross-examination, on the whole, on the balance, I can place faith in what they've done during this investigation and ultimately in the conclusions that they reached.
I take it you thought that they were credible on the stand. Is that right?
I mean, yeah, it was a long trial, but I think the law enforcement witnesses were reasonably credible. The housekeeper and the drug dealer I see their testimony a little differently.
Mm-hmm. Did you have a chance to hear the testimony of the private investigator that that Eric Richins' family had hired when Kouri had sued them to assist in the civil litigation? And he was on the stand for quite a while, and the defense really went after him. Did you have a chance to listen to that testimony?
Jo, I've reviewed summaries of that testimony, and I did see bits and pieces of that.
Okay. So of the bits and pieces you saw, were you able to form an impression of him on the stand? I'll tell you, the chat
Yeah.
was all over the place with regard to him.
He's kind of a hired gun in a sense. Even private investigators, they're supposed to maintain some objectivity. They're not supposed to sort of do a beeline towards a predetermined conclusion and then find evidence supporting that conclusion after the fact. I think there were some questions as to, his objectivity and really, what was his interest in it. He's being paid for it, of course, and the reasonable conclusion is he's being paid to come to certain positions and certain opinions, and could that have influenced sort of the trajectory of the investigation? Could he have tailored the investigation towards what he believed to be a foregone conclusion? I think that those challenges were valid.
Yeah, there were people in the chat who thought that he was a little arrogant. He was a little maybe disrespectful of the defense lawyers. I don't know. I don't think you could pick that up really very well from the dry transcript, although I think some of the answers might have given you that hint. Was that your impression of him? Did you form an impression about that?
Along those lines, my impression was that he was overly combative. So with the defense lawyer, he's nitpicking some ridiculous stuff that the defense lawyer is asking, pretty direct, honest question, and he seems to be trying to slither out of it at times based on some kind of technicality, and I think that you really lose credibility with a jury on that. The better approach is to just be straight up, man, and to just answer the questions, and whatever the answer is, it is. But if you start looking like you're trying to slither out of things, you start looking like a snake, and juries don't like snakes.
Yeah, he was, as I said, the chat was all over with regard to whether they thought he was doing that or he was straight up. And of course, the defense, and I wouldn't be surprised if this is one of the issues on appeal, because they tried pre-trial to suggest that he was really an agent of the state, because he was providing the law enforcement information from the investigation he was doing in the civil trial. And they lost that motion pre-trial, and I'll bet that they will raise it on appeal again. I don't know what your view of that is. I think they're going to lose, because I think what the evidence seemed to show was the state said, "Oh, thank you, we love it," but they didn't say, "Okay, now go find this because we can't get a warrant." And I also think he's protected by the fact that he really did have the independent job of helping the family in the civil trial. So a lot of what he was doing really related to the civil litigation. So I'm telling you my impression of it. What is yours? I mean, you do lectures on some of these constitutional criminal issues.
Totally. So I think the way defense is going to see it on appeal is they're going to say, "Hey, look, my client is entitled to all of her constitutional rights, and the government cannot violate those rights with, unlawful searches with a search warrant, things like that. Nor can an agent of the government. So if the government were to enlist a private investigator, so any private person, to sort of do their dirty work investigatively in a way that may sidestep the Constitution, then that's a violation. That's problematic. That's just the same as a lead detective engaging in investigative measures that violate the Constitution. So that's how defense is going to argue it on appeal. Whether he really was an agent and whether what he did was actually violative of the Constitution, I think those two things are truly disputable. And I'm not sure that is going to win the day for Kouri Richins on appeal.
Yeah, I agree. I'm more convinced that it won't. That it won't. But I agree with you that that's what they're going to have to be looking at. What about the financial evidence? The judge kept most of it out. It's going to be in a different prosecution that's coming up. He allowed 3 counts in, and I think the dividing line he used was it had to have some reasonably direct relationship to Eric Richins and the murder of Eric Richins. I'm reasonably confident that the defense will raise on appeal that none of that evidence should have come in. Do you think they will have any success with that? argument on appeal?
I think the judge's severance of some of those financial crimes was totally appropriate and was really a cautious measure to protect against an appeal. We look at the Alec Murdoch case, and in that case, the prosecutors spent I don't know, almost a week or so just on these financial crimes, dragging Murdoch through the mud, saying he's screwing over his clients and taking their money and everything else. What did that have to do with whether he killed his wife? And in fact, in the Murdoch case, that is a primary ground for appeal that's presently being considered. So I think in this case, contrasting, the judge was smart to say, hey, look, we're going to be selective about the financial crime evidence that we allow in at this trial. It was limited in such a fashion that I think an appellate court's going to look at that and say, I think trial judge, I think you made the right call. We're not going to overturn this murder conviction because, one or two potential financial acts got in that shouldn't have.
Yeah. I don't know if you watched the appellate argument on Murdoch or read the briefs.
Yeah.
I thought that actually both of the claims the defense made there have a reasonable chance of getting a reversal of that conviction. Now, partly it's going to depend on the claim that there was so much other evidence in the record. What difference did it make? At least on all the financial stuff that came in. On the court clerk talking to the jurors. Did you watch that oral argument? That was.
I've watched pieces of it. I'm very familiar with it. Yeah.
Okay. What did you think? I mean, I'll tell you. Well, let me ask you, what did you think about the court's reaction to and treatment of how the former Supreme Court justice handled the motion that the defense made with regard to Becky Hill?
I'll take the unpopular position here, Joe, that I think Becky Hill has undone that conviction. And I think it's reasonably likely that the Supreme Court is going to overturn Alec Murdoch's conviction based on the actions of this court clerk, Becky Hill. I think that what she did was so beyond the pale and truly influenced what happened in that deliberation room as attested to by at least one of the jurors. And so I think Becky Hill screwed that up royally. And I think we're going to see an Alec Murdoch part 2.
Yeah. And I heard a couple of defense lawyers say they thought it was going to be a stacked deck when the Supreme Court designated the former Supreme Court justice to hear that motion, because they felt, well, they're never going to say anything negative about one of their colleagues and someone who presided over the court. But boy, they didn't have, from what I listened to, they were silent at times, but they didn't have a good word to say about how she handled what she kept out, what she allowed in, the decisions that she made. So I actually agree with you that there's going to be a reversal there.
Yeah, I see that coming.
Yeah, but I jumped you to Murdoch when you were thinking about Richins, so I apologize for doing that. But,
it's all right. I'm with you.
So let me see if actually I should see if there are any questions in the chat, because I hate to not let them go, and I don't see any. Oh, here we go. Do you think her attorneys prepared her well for a guilty verdict? Shaker Maker thinks she actually thought Kouri Richins was going to pass out when the first count, I think, would be when the first guilty came in.
My speculation is that Kouri Richins didn't think she was going to be convicted, regardless of what her attorneys told her. That they could have prepared her until the cows come home for this contingency. And I think Kouri Richins is the type who is so detached from reality, so detached from consequences that it wouldn't register. It is that she would sort of disregard that. We look at some of her other actions in the case, sending that wag the dog letter, like I said, knowing the jail staff is going to look at this, doing these internet searches that everybody knows if you're suspected in killing your partner, they're probably going to look at your phone, bro. Like, the actions that she took just seem so detached, such that any advisement her attorneys likely gave her regarding the potential outcomes here, I wonder if it just wouldn't have gone in one ear and out the other. And then lo and behold, she's so shocked when it's guilty.
Do you think she was relatively receptive to the advice that her lawyers gave her and the decisions about who to call, whether to call witnesses, and the general theme that they were going to use in the defense? Or do you think she fought them about it and wanted her own way? Do you have a feel for that?
Oh, sure. I mean, there are clients who, there's a spectrum, right? So there are clients who are like deferential to your expertise, and they're like, hey, dude, like, you're the pro here. You make the calls and we'll do this collaboratively. And there are clients who are like, I'm smarter than you. I know this better than you. I know what I think the outcome's going to be. And so screw up. And I'm wondering if Kouri was a little bit more towards the latter camp in terms of some of these decisions, because those can be difficult conversations to have with a client, and especially if they are so sort of one-track mind in terms of what they think happened and what they think the best defense is and how to present it. That can be really difficult during those discussions, really difficult for the attorney.
Mm-hmm. And you've had clients like that, I am sure.
I've got clients like that presently, yes.
Oh, boy. So, let me think. Is there anything about the trial that struck you that we haven't talked about?
Gosh, I thought that defense could have had more traction in more effectively calling into question the credibility of the housekeeper and of the drug dealer. Those things, the drug dealer is talking out of both sides of his face. He's given multiple contradictory statements. And on top of that, there was some immunity that was extended. And I think that those things could have been touched on more to show, like, hey, not only are these people like not people you should believe, but on top of that, they have an interest in the outcome of this specific case. And the only way for them to serve that interest is to tell you what the government wants them to tell you. So they've tailored their testimony towards that. And you cannot place faith in that kind of testimony. I think that they could have hammered on that more effectively, and really made that a central piece of this. Sometimes you got to take your worst fact and try to turn it into a good fact. You got to spin it in that fashion. I thought they could have done a better job on that.
Okay. So what would you say is the best thing the defense did?
The fact that I have to pause to think about that is a problem.
That question froze you.
Yeah, you've got the fact that I don't have an answer at the tip of my tongue for that is a problem. I think that they did a fine job sort of going after the private investigator. I think they did a fine job cross-examining some of the law enforcement and talking about things you did and didn't do and could have done. I thought that those things were fine. But there is not one single thing that jumps out at me where I'm like, and I'm not trying to cast aspersions. I'm not saying they did a bad job, but I think they had a really difficult case. And I'm just not sure, they played the hand that were dealt in the best way that they could, and they came up short.
Yeah. Well, we talked a little about the prosecutor and how his demeanor might have affected the jury. What about the two defense lawyers who did most of it? Ramos did a little bit of the defense, but not as much as Lewis and Nestor did. Do you have a feel for how their demeanor and their attitude and the way they asked questions had an effect on the jury? There are the three of them, and Nestor's in the middle, and Lewis, who is the lead defender, has got her back to us.
Yeah, my apprehension is that some folks believe they at times came off as disrespectful. They at times came off as abrasive. And it's tough. You got to walk a fine line because as defense, you can't be a pushover, and you can't just say, "Oh, yes, sir, you're absolutely right," to an officer who was accusing your client of something. But you also have to be cognizant of the delicate nature of the subject matter we're discussing. We're talking about an innocent person who's dead. And even if your client didn't do it, that doesn't mean you come out guns a-blazing and I think they were snarky at times. And that's a difficult thing for a jury to receive. They might be thinking, oh, they're putting on all this bombastic sort of bravado because they lack substance. And I'm wondering if that was an interpretation by some of these jurors of how defense presented this case.
Did you think the judge did a good job?
I like the judge. I think especially, and this is just sort of like a law kind of nerdy thing, but the fact that the judge had severed some of those financial counts from the outset, I thought that was super smart because the prosecution already had enough. It wasn't necessary to go through a litany of all of these financial issues in order to prove that this person is guilty of murder. And if the judge would have allowed those things, that is huge grounds for appeal, talking about other acts that are attenuated, that aren't directly tied to what happened. I thought the judge made some smart rulings in terms of preserving the finality of what would be the conviction that was ultimately had.
I thought he had an exceptional feel for the rules of evidence. Really, really first rate.
Yes,
Probably
absolutely.
better.
When they were taught. Oh, go ahead. Sorry.
No, go ahead.
I was just going to mention, there was a dispute about what they could ask the friend Kouri, I think was his name, about regarding things that Eric may or may not have said in terms of recreational something or other. And the judge was very precise and very nuanced and said, hey, I'm not going to allow you to talk about, high school drug use or something, in part because it's not directly inconsistent with what evidence had come out previously. That's usually the way you can get in that stuff, is if it's inconsistent with some evidence. But the judge parsed it out, was very reasoned, was very principled in my opinion.
Yeah, I agree. And he also did a very good job of preserving the record. He did about as good a job of explaining his findings as any judge I've ever heard. So I agree with you. We're going to run because we're at, I don't want to be really selfish of your time. You've been very gracious to give us your time, and we really appreciate it. We're going to run through quickly some of the questions that came up in the chat, if that's okay with you.
You got it.
Here's one. Do you think the defense lost credibility when they tried to imply Eric was in a sexual relationship with his best friend, Bryce? And they did. I don't know if you saw that part of the trial, but they did do that. Yeah. That was when the PI was on the stand.
Desperation is never a good look, especially in a jury trial. And when you are pulling at straws and you have what appears to be a heterosexual person who's married to a woman and created children. And for really the first time we heard anything like that was at trial. This hadn't sort of been a talking point about the case for a period of time. I think grasping at straws and going to those lengths reeked of desperation. But Kouri Richins' camp was desperate. So, what are they going to do?
What do you think their theory was of why it was relevant to her not committing murder? I mean, that was my question. Throw mud at a victim, I don't like it, but what was the relevance?
I wonder if the relevance was, we got to make Eric look bad too. And I'm not saying that this act would make a person look bad, but perhaps that was an angle that they were trying to think. Gosh, my client Kouri Richins looks like the villain. What do we have any dirt on this guy? What's some dirt that we can try to dust up and see what happens? That was my interpretation of it.
Okay, Shaker Maker wants sentence predictions. I don't know if you know what Utah sentencing is, but the murder one aggravated is I believe it's 30 years. Well, they took out the death penalty. I think it's 30 years to life without parole. And the other major one, which is the attempted aggravated murder, is one level down. It's a felony one, and I believe it's 5 years to life. And after the minimum is served, it's the parole board that sets the term. So
would not be surprised if this is a life without parole sentence coming down. And the reason I say that is because, it wasn't some, gang murder in a parking lot where you have warring sides over the course of time who have harmed each other forever. It wasn't like some bar fight that escalated and just got out of hand in sort of a very quick fashion. There were two components that the judge, I think, is going to give significant weight to. One is the alleged prior poisoning. The alleged prior poisoning from Valentine's Day, that the judge can be like, hey, this isn't something she woke up one day and in a horrible, poor judgment state decided to do. She'd been planning this. This is something she had thought about for quite some time, poisoning her husband. The second piece that the judge may give great weight to is that she tried to profit off of it. It's bad enough to off your partner and end their life. But my gosh, if you're trying to secure some benefit for yourself as a result of that, the judge is going to look at that and say, we look at all of these pieces. This makes it pretty egregious. So I think we're looking somewhere in the neighborhood of life without parole.
You think he'll run the attempted aggravated murder consecutively?
Probably, yeah. Typically, when you have multiple crimes of violence in most states on which convictions have been rendered, those sometimes have to be run consecutively. What I meant to say is that I think they're going to run them consecutively. I think, that there will be two sentences and they're going to stack on top of each other as opposed to running at the same time. Either the law is going to mandate that, or if it doesn't, I'm sure the judge has discretion to run them consecutively. And when it's a serious thing, you're likely looking at consecutive.
Yeah. Okay, here's another question. This is from Lee. Do you think Kouri kept making facial expressions even after the defense warned her not to? Now, we don't know whether the defense warned her not to, but do you think if the defense had warned her not to, would she have continued to do it anyway?
I think Kouri Richins is going to do what Kouri Richins wants to do. And I think that all the advice from counsel in the world isn't going to change that. And I think that she was going to give her demeanor in there, right or wrong, and regardless of what anyone else said.
Okay, so I just got one here from CMBBBY, which is probably the easiest question that's come up. Do I think they will appeal? Absolutely, yes. They will appeal.
100%. 100%. Anytime there's a murder conviction, especially a trial, that appeal is coming. It's going to take probably years to resolve. But I don't see any glaring meritorious grounds for appeal.
I don't either.
Yeah.
And now they've got the financial crimes, which I think are above 20 counts, that I suspect they will now go forward with. I don't know what the statute of limitations is on the the financial end in Utah, but I don't see any reason for them to wait now.
No, they're gonna go gung ho on that, and there are some weird similarities to the Alec Murdoch case because he had a number of financial crimes on which he was convicted. And so even if his murder conviction is somehow undone, he's still got these lingering decades-long sentences on the financial side. I imagine prosecution in the Kouri Richins case is going to buttress this murder conviction with some additional convictions and sentences on the financial crimes so that, God forbid, something weird happens on appeal. Well, we got this fallback. She's going to be in a box anyway.
Right. Okay, Athena wants to know if sentencing is 100% in the judge's discretion. I'll let you take that. Go ahead.
Sure. Yeah. I mean, it varies by state and varies by crime. Typically, the judge does have discretion with respect to whether to run sentences consecutively or concurrently, regardless of other circumstances. And then if the judge does have some latitude in terms of the sentence they can give, I still think it's going to be at the high end. I think it's going to be life without the possibility of parole anyway, slice it.
Yeah, I do too. Okay, here's another one. Do you think Kouri convinced Eric? Like there was evidence that Eric thought she was poisoning him, and told his a couple of his friends that. It never came into evidence, obviously. But okay, so you think Kouri convinced Eric that the February 14th poisoning was COVID, as she stated on the night of the murder, that the family tested positive 2 weeks earlier?
That would certainly be a reasonable opinion to have. That's kind of how that played out, because he's feeling these sensations in his body, and he's like, what in the world's going on? You don't want to think that your loved one, or at least a person for whom you do or had love, would do that to you. And so I think that person can be easily convinced of some alternative explanation. Wouldn't surprise me if that's how it played out.
Yeah, he had, I think, I don't know whether on another trip, thought maybe she had poisoned him. And there's also Josh Grossman, the handyman that she brought out to Utah, who was living in the houses, and he was, rehabbing them, and then she was paying him money here and there to do it. Also had an episode, I don't know whether it was a Twinkie, I've got the food wrong, where he had a bad reaction to it, and I think it was something that she either gave him or made for him. I think it was right after the murder, and he had texted her about it. He said he slept for several hours, and there are people who believe that she may have decided she didn't need him anymore, and that maybe that was another attempt, but we'll never know. Okay. MJM A59 wants to know what prison she will go to. Well, I don't know Utah. Derek, do you know anything about Utah prisons? I have no idea.
That is an adjacent state, and so I should know, but I'm not sure about that. When deciding prison placement, there's a number of considerations, including the nature of the conviction, the high-profile nature of the defendant, as well as prior criminal history, of which I don't think Kouri Richins has much, if any. Number of factors, but I don't think it's going to be like a nice white-collar Martha Stewart prison.
No, she's not going to the prisons that rich people go to.
I don't think so.
Okay. What do you think about, one of the trial lawyers here is on the Charlie Kirk, is one of the defense lawyers of Ty Richardson. Is that what his last name is? In the Charlie Kirk trial. And what the question is you're getting here is how you think she'll do in that trial.
Yeah. So she's no stranger to high-profile trials, and that's something you kind of have to develop a callus for. You have to sort of be ready for that, because it can sort of shake you. So the fact that I doubt like nerves are going to be an issue, which is important. I think that at least what I've seen in that Charlie Kirk case, she's done a good job so far in terms of raising the issue she has to raise. She tried to get the DA's office disqualified
The
in a rather creative
office, right?
right, the entire, yes, right, in a rather creative fashion. And so I had to sort of give her kudos on that. I thought that was a creative use of that law. She ultimately was not victorious, but I think she's still got some stuff up her sleeve. And I imagine we're going to see that in the coming weeks and months.
Yeah. My concern about that trial is I think it's a new judge who's on the bench. And my observation of these lawyers in this trial is they need a really strong judge, because they will push and repeat push and make arguments that I don't think have much chance of being meritorious. They once in a while cited cases that didn't support what they wanted to say. And if they don't have a really strong judge, that trial can go forever and be quite more of a circus than I think it's going to be anyway.
was already in the multi-day hearings on the motion to disqualify was already a circus. It didn't
I
need
know.
to be that long, didn't need to be that extensive. I thought that judge was being overly cautious, overly kind of deferential to defense in some ways, in terms of not wanting to create error that would lead to some conviction being undone. But not trying to cast aspersions, but I didn't get the best impression of that judge.
Did you I think I'm right that he's new to the bench. I think he said something at one of the hearings. Does it surprise you that they would, that the chief judge or the assignment judge would put on a trial of that level of public scrutiny a new judge rather than pick one who's got experience with major cases?
Put the chief judge on there. Why would you not do that? That makes the most sense,
Okay, so you agree that it's a big surprise.
Yeah. I think, there was, and again, I'm not trying to talk mess about anybody, but just make an
No.
observation that in some of the judges' hearings that were publicly recorded and shown on TV, there's a lot of trepidation in his voice. He seems like kind of like scared up there and a bit passive, and that's just not, you need kind of a commander who can command the courtroom as the judge, and everyone has different styles, and I'm hopeful this judge will do a great job. But those were just some observations I have.
Yeah. Well, you get more confidence with experience. I mean, I thought it was akin to having maybe, let's say, the Vice President of the United States come in with a major injury, and you assign the surgeon who was just just finished his residency, rather than bring in, somebody who's done surgeries or, has experience with them. But okay, so this one's for me. Nancy Drogan, yes, I prosecuted. I do not have the level of experience that Eric has by any means, but I did take a sabbatical from teaching and prosecute for about maybe a year, 15 months. I loved it. I just loved it. But, okay, it looks like that's all the questions. Why don't you tell us, if you would, what you're doing now and what you predict that you'll be doing in the next maybe year or two, 5 years or more if you want.
Yeah, totally. So I'm the founding partner of the law offices of Eric Faddis. We're based out of Denver, Colorado. We do primarily personal injury and wrongful death, but I keep a select criminal defense docket for death cases just like this. I also do a lot of TV, legal and political commentary, News Nation, Fox News, Newsmax, Nancy Grace, other outlets like that. We are in the process of expanding the firm. And, if you live in Colorado, you might see some cool commercials coming out. And, from there, yeah, feel free to hit me up. I'm on Instagram at E_Fad, FAD. Also at the Mile High Lion, which is my moniker, Roar. Come check us out. And just super stoked to be on here. And thanks for having me.
Great. Well, thanks so much. I really appreciate it. I hope you'll come back. And I know that the chat, and I can't read it while I'm doing this, but the comments that I did see were just very, very highly favorable, which is no surprise. And I will say to people in the chat, if you've got, a civil case, I'm not going to say criminal case because I don't want you to go out to do a crime in order so you can get a top-rate criminal defense lawyer. But on the civil side, if you're, in Colorado, but you practice primarily, you don't go outside Colorado, do you? Or do you?
Well, we take, on occasion we will. And we take federal cases as well.
Federal, yeah.
Especially death cases on the civil and criminal side. If those things arise and it's the right case, happy to explore that.
Okay, you heard it. You heard it out of Eric's mouth. So, and he gave you his information. So now it's up to you. Okay, thank you so much. I really appreciate it. So we'll see you again, hopefully.
Sure.
Okay. I don't know if there are any more questions in the chat that I can handle. I think if there are, you had the expert there, and I would hope that you availed yourself of the opportunity to ask him But if you do have anything, I'll stay for a minute or so and see what your questions are before we go off. I know that some of you had said he's, a really good guest, and you said the same thing last night. And I will say that's due to Steve Cohen, who investigates and finds some really great guests who have expertise and personal knowledge and the ability to articulate and explain. So I'm really grateful to him. And I don't think I see anything else. Is Kouri in jail or home? Oh, she's in jail. She's been in jail since her arrest. And she's not going anywhere now that she's been convicted of aggravated first-degree murder and 4 other counts. So if she hadn't been in jail before, she'd be in jail now, but she's been in jail since the arrest. This is CMBBBY. I don't know. Is that supposed to be pronounced? Because if so, I don't know how to do it. I don't know what to do. Okay. What do I think of the Sky stuff? If you mean that she said she had a conflict and had to recuse herself, I don't know. She's never said more than it's a conflict. And if you mean that she was in court sitting next to Kouri's mother for the sentencing, I don't have an answer to that either. I heard her say, well, I did, because I was on the program with Joel, now that I think about it, right after the conviction, that her impression of Kouri is not what most of the public has of Kouri. She found her to be a personable, I don't know if she said kind, but positive things to say about Kouri. So, and that's all I know. I couldn't possibly say anything else because I really don't know anything else. Okay. So you say Eric has a great personality. That's true. Donna KU wants to know what's next. Well, I'm waiting for suggestions by you all. I don't know what trials and when they're scheduled. And I had a couple of people suggest 1 or 2 things, but you signed up and you were given that cap. Can't you change it? I can't believe that there isn't a way to change CMBBBY 17B to something else. But I don't know anything about this stuff. So my can't believe doesn't mean that it isn't true. Will I get to watch Sky on Courtroom Confidential? I might. I mean, I've got the time difference here and I'm doing other things. So, I don't watch, I don't always watch a lot of the other programs that are covering trials, but I try. Okay. Okay, here's one. Why didn't the prosecutor bring up the $11 million she claims she made from the $250,000 home equity loan? I don't know. I mean, some of it is, you heard Eric say, some of it is tactical. You might get it in, but it's not going to move the needle much. And you have to worry about whether there's a objection to it that might be something that's that might turn out to be an appealable issue, and you really have to be careful. I mean, you want to win a trial clearly, but you also want to be careful that you don't win a trial by the introduction of evidence that an appellate court is going to say shouldn't have been heard by the jury. Now you got to do it again. Okay, Irene, same Yoerness. Why do I think Kouri reached out to the housekeeper again after Eric died for more pills? I don't know. Unless, it would be pure conjecture, and I'm not going to guess about that. So I'm going to say I don't know. Okay. Okay, so CMBBBY 17B says everyone knows him, her by that now, and I can pronounce it any way I want. You might do the name you want, and then in parentheses, formerly known as. That would be a long name, but it would give you a chance for a while, and then you could get rid of the formerly known as part. But I hear you. You've been doing it for a while, and you're happy with the name. It's it's a neat looking name. It doesn't pronounce. That's all. Okay, Catherine Meconico, a super sticker. Thank you so much. And there were a couple others that came through Annalie Finch, thank you. I think you've given me a super sticker before, so I really appreciate it. Thank you, thank you. Oh, and this is Elena Vanilla Bad. Thank you so much. Oh, and you did it in euros. Isn't that cute? Is that really coming in euros? You know, if you do it in euros, it's more than $5. I can attest to that. The exchange rate is really bad right now. I appreciate it. Before I sign off, please hit like. You just have to hit a button. And I don't know why on these programs it is on 100% like or 80% like, because all you have to do is hit a button. And you can hype the videos, which would be really great because, as I've said before, it moves videos up in the algorithm and it gets them seen by people who don't know that maybe Prof Jo exists. Prof Jo Explains exists, so that's really great. For those of you who are subscribers, thank you very, very much. And for those of you who are members, absolutely thank you very, very, very much. So Sherry Lelas, can Kouri stand in the way of the sister's custody of the boys? We did a video on that last night. And I recommend to you that you look at that video because we had an expert on issues with regard to child welfare and how the family court system works and what would likely happen, but what is within the realm of possibility of happening. But I will summarize quickly. Kouri can attempt to do that. Her chances are not very good at all. Okay, but she did a lot more than I just did. Okay, I guess CMBBBBY, thank you so much for the 10 for the super sticker. And I guess I should continue to criticize because not criticize, but make suggestions because I make a suggestion and you send more money. Okay, we'll stay with CMBBBBY. It's wonderful. Okay, Italiano Behemoth says, and anyone mentioned Kouri's maiden name? I don't know what it is. Do you know? I have no idea. Probably it's out there somewhere in the internet, but I just have never seen it. So can't talk about that, at least with any degree of information. Anything else? I bought this in Sorrento, by the way. They've got big sales going on. And so I got back from this little town today, which is really cute. I did a short on it. And then on the way home, I passed a store and I couldn't resist. So I also went to church, but I also went to a store. So is there anything else in here before I sign off? Doesn't look like it. I will give you 2 more minutes and then I'm gonna have to, then I will just say good night. Oh, her name. Oh, I did know her maiden name. Thank you, Leo Wren. I had seen Darden because Lisa Darden is her mother and Ronnie Darden is her brother. And I saw Darden in both those names. I just didn't put it together, but that's not as bad. I had one worse today that I didn't put together that was so obvious. It was just embarrassing. Oh, I know what it was. I'm going to a buffalo farm where you can get buffalo mozzarella, and we're having lunch there. And I had told my Italian instructor a couple of years ago that, I know about buffalo mozzarella. I mean, they sell it in New Jersey, and I know it comes from buffalo. So let me tell you 2 things. Nonetheless, I told my instructor that, they didn't have buffaloes in Italy. I had this information over here that clearly had to mean there are buffaloes in Italy, but I didn't make what is an absolutely extraordinarily obvious connection. So sometimes the synapses don't shoot out in the right way. And by the way, I don't know if you heard it, but they were shooting off firecrackers here earlier. Tomorrow is the feast of St. Joseph, San Giuseppe, and it's also Father's Day here. And in New Jersey, they have, and other places in the States, and on the Amalfi Coast and in Naples, they have Zeppoli di San Giuseppe. They're a pastry, and I'm going to buy them for everybody who is here tomorrow because it's my omni Gnostico, I think is the word, my patron saint. Okay. TD3 Nation wants my impression of Lewis raising her voice and trying to get an emotional rise out of the jurors. I don't know that it was effective, but she certainly showed her passion, and I think it was a sincere passion. I think she really meant what she said, at least about caring about the jury doing its job thoroughly and carefully. She's also said she thinks Kouri is innocent. I don't know whether that's the truth or not. Okay, Jewel Casablanca wants to know when I'm returning to the U.S. in about 2.5 weeks. So, okay, anything else about the case? It's mozzarella di bufala. Yeah, and the bufala are buffalo. And I know all that. And I know that it comes from Italy, and yet I blithely made the claim that there were no buffalo in Italy. I mean, the brain just didn't make the connection. Okay, Neelan says tomorrow is her birthday. If she was a boy, she was going to be named Joseph. Funny enough, her husband's name is Joseph. Well, there you go. So your birthday is on the Italian Father's Day, and it's his namesake. And if you can get Zeppoli di San Giuseppe, you might want to do it. I'm not a big fan of pastries, but I'm going to get them for everybody in our group. Okay. All right. I'm not getting any more questions about the case, so I'm going to sign off. Have a good evening. You still have time to have dinner. So thank you for viewing. Thank you for hitting like. I would like to hit 100% like someday. It would be quite the extraordinary achievement that I don't think anybody has ever achieved before. And I would like to be the first. Please hit hype. If you're not a subscriber, please think about being a subscriber. And to my members, I really appreciate you. Okay, so long.